Thank you, Mr Chair, Mr Speaker. I'm very pleased to speak on this bill, the Resource Management Required to Authorities Amendment Bill, in the name of my colleague, the Honourable Ruth Dyson. I was interested to listen to the language from the MP for West Coast Tasman, Mr Okenvold, who talked about this bill could increase red tape. It could impede progress. I think what, in fact, the government wants to do is to cut some red ribbons, some red tape on new water projects in Canterbury. The Prime Minister has defined in his statement to Parliament last month that he wants to see real progress on water allocation in Canterbury. So it's little wonder that Mr Okenvold is defining that this bill may deflect things that are being in the public interest and suggesting that that might be excessive. And I want to suggest that what we might well see from this government, in alignment with the sentiments expressed in voicing opposition to this bill, is a move to breach not just the fundamental property rights that my colleague Shane Jones referred to, which you would expect to be a fundamental principle of the right, but what we're also, I think, expecting to see very shortly, as early as next Monday, from the Cabinet with announcements on the future allocation and management of water in Canterbury, is the breach of another fundamental principle, and that's the fundamental principle of taxation without representation. Because I think what the government is prepared to do and poised to do is, in fact, remove the democratically elected organisation, ECAN, from the management of Canterbury Water, and instead install a commissioner, perhaps in the form of Jenny Shipley, former National Prime Minister. Perhaps the Minister is welcome to comment on this and confirm if the speculation, which he has not yet denied, is correct. So what a segue we've got here. What a segue we've got, because we've got the former Deputy Prime Minister, Mr Wyatt Creech, a member of the Open Country Dairy Board, which has breached environmental law on a number of occasions, followed perhaps by his Prime Minister Jenny Shipley as the Commissioner for ECAN. Jenny Shipley, of course, a very good friend of Ruth Richardson, who happens to be on the board of Synlait and Dunsandel, another dairy company, and the ideological soulmate of Don Brash, who is on the board of Oceania down in Waimate. So we can see why this government has a view, why we do not want to see an amendment to the Resource Management Act which suggests that matters should be designated in the public interest, that should see a requirement that works should only be authorised if they are necessary. And therefore that's why we're hearing the language from the government tonight. So it's little wonder that the people of Canterbury are beginning to ask questions about what's actually at stake here in terms of the management of Canterbury's water. When we see the signals that this bill presents from the government tonight, signals are Cabinet will decide on Monday. We've got signals from the Prime Minister that he wants to see the rapid allocation of water. He wants to get on the board some very quick economic runs. And I heard the MP for Taupo talking about environmental balance. Well, in my experience, environmental balance always comes second to economic growth, especially when this government is involved. And we've already seen the environmental balance in Canterbury put to one side because there is no capacity any longer to swim in the waterways of Canterbury, in the streams of Canterbury. And who's going to accelerate? Who is going to accelerate the process for allocation of water? We've had an acknowledgement there has been problems around the allocation of water. Why would we want to accelerate more allocation without fundamental changes to environmental protections being put in place first? You cannot have it both ways. You cannot have blue-green. What you're going to get is blue-brown. And that's what's going to happen across the waterways of Canterbury if legislation like this continues to proceed. And what I would like to say is environmental balance has always come second. Public interest has come second. This bill is an attempt to signal that public interest should come first. Public interest should come first. I do believe this legislation should proceed. And I think this government, when it comes back to some basic precepts, it should say that public interest should come before property the interests of those who have property. It should protect property rights, and this bill, of course, acknowledges that in the case of Central Plains Water, the rights of property holders were put second to the interests of a particular and small group of trustees, all of whom came on board to that project. And the government should also be acknowledging a principle, a fundamental principle one expects from parties of the right, that when you are going to have taxation, it should come with representation, and that's certainly not.
I regret to advise the member that his time has expired.